I'm Dr. Delores Jones-Brown from John Jay College of Criminal Justice. I am in the Department of Law, Police Science, and Criminal Justice Administration, and I'm the founding director of our Center on Race, Crime, and Justice. I'm so excited to be here with you today with my wonderful colleagues who are doing magnificent work around this very important matter. Our panel is The Anatomy of a Drug War, Criminal Justice, and Collateral Damages. We're not going to go in the order that is laid out in the program. We're going to begin with Dr. Marc Maurer, who's going to give us sort of the background of race in the war on drugs. Then we're going to go to soon-to-be Dr. Dwayne Nash to talk about the front end, which is police contact in the war on drugs. Then we will transition to prosecution, because once the police arrest people and they get prosecuted, and then Whitney Tymas will tell us about prosecution and its relevance to the criminal justice and collateral damages of the war on drugs. We will then look at some of the consequences of people being swept into the system via this war on drugs and its consequences in terms of the employability of those who have had this contact. And we will end with Deborah Small talking to us about the punitive paradigm in the African American community and how arguably that has contributed to the approach that has been taken to the war on drugs as it focuses on folk of African ancestry. I didn't originally have bios for everyone on the panel, so I'm going to ask each panelist to say a little bit about yourself and your connection to this work before you begin your presentation. And I will be a somewhat ruthless timekeeper so that we will have an opportunity for folks in the audience to ask, I'm sure, what will be very provocative questions about this situation. So, Marc, if we can begin with you.
Well, good morning.
Good morning.
Good. I'm delighted to be here. My thanks to the Institute and all the people who put this together. You know, it's a wonderfully diverse group of perspectives that we've had here over the last day and a half or so, and these issues are very critical. In terms of background, you can see some of the bio notes in there. I'm the executive director of the Sentencing Project. Probably the most important thing you need to know about me is if you look at all those charts on the growth of incarceration, you know, we see for much of the 20th century the number of people in prison was pretty steady, and then we see the number just skyrocketing, you know, over the last 4 decades or so. My career trying to promote alternatives to incarceration was right about that point where the graph starts to go off the chart. So if you want to look at effectiveness, you know, we don't want to measure it by how many people I've kept out of prison or anything like that, but it's not for lack of trying or so. So we're talking about the drug war. There's been a critique coming from many different perspectives here at the conference. But I think it's important to recognize that there are what I would consider to be some well-meaning practitioners out there, prosecutors, law enforcement executives, and others. You can find them all around the country, who I think sincerely believe that this has been a good and productive strategy and has been a necessary strategy and one that we've needed for this country. So I want to lay out what I think one of these, let me call them a thoughtful prosecutor, if he or she were on the panel, how they might describe the drug war and its impact, and then try to critique that. Because I think it's important for us to understand how this is being framed if we really want to make a change in public policy. So here's what I think they would say. First, they'd say, you know, crime rates have been going down nationally since the early to mid-90s. This is at a time when the incarceration rate has continued to be rising. Therefore, it's working. We put more people in prison. We have less crime. If you look at drugs, crack cocaine in particular, starting off with that, crack cocaine, we see this epidemic starting in the mid-80s. We put in a bunch of tough laws, prosecutions, and by the early 90s, crack cocaine crimes, crack cocaine-related violence is going down pretty sharply. When it comes to marijuana, all you reformers, making these arguments. It says there's all these pot smokers, filling our prisons. That's not the case. People in prison for marijuana offense are only the people who have been selling at high levels. You don't go to prison for marijuana. Also, the argument about low-level offenders in prison. Most of the people in prison for a drug offense are not there for possessing drugs. They're there for selling drugs. So this is a very different kind of situation. And finally, I think they'd say when it comes to racial disparity, people get involved in the drug trade are going to go to prison. It may be unfortunate if we see disparities, but this is what we need. This is what communities of color are demanding that we do to take care of these drug problems. So I think that's the argument we would hear. So what do we know about the validity of this argument? How does it hold up in terms of what we might want to see going forward and all that? So first of all, crime rates, yes, have been going down since the 90s while incarceration has gone up. There are many factors that produce changes in the rate of crime. Incarceration is only one of them. If you look at the best academic studies, the most optimistic ones say that maybe 25% of the decline in violence is due to rising incarceration. Other good studies suggest it's only 10% may be affected by rising incarceration. Even within that, there's, I think, a fairly broad consensus among researchers that whatever effect incarceration has on crime, we're very much past the point of diminishing returns. Basically, the more we expand incarceration, the more we're bringing in less serious offenders and therefore having less of an impact on crime. Further, to the extent that incarceration has some effect on crime, this doesn't mean that it's incarceration compared to doing nothing. If we're spending $80 billion a year on incarceration, suppose we reduced incarceration rates by 20% and we freed up $16 billion. What else could we be doing with those funds that might have an impact on crime? I think that's the question we do want to be asking. Second part of the prosecutor's argument, the crack cocaine epidemic. We put tough laws in effect, and then we saw declines in crack and crack-related violence. Well, the toughest laws, went into effect by Congress, 1986, the infamous harsh mandatory penalties for crack cocaine. Despite this and the fact that many states were adopting similar policies, the crack epidemic, continued through the late 80s, early 90s or so, even as these prosecution stiff sentences were piling up. So in terms of sending a message, putting people away, there was certainly no immediate effect that we could see. What we do know is that looking at drug epidemics over 100 years or so, and there's been a number of them, it's not at all unusual what we saw when it came to crack cocaine. That is, new drugs come along, people, mostly young people, start to use them. It often involves, changes in drug markets, and we have some very serious problems, but they are relatively short-lived in retrospect. Many of the drug epidemics last for a period of 3 to 5 years. This is not to downplay some of the harm that comes about through it, but it often sort of plays itself out. The younger brothers and sisters look at their older siblings who are getting strung out on drugs, who are getting caught up in violence, all sorts of neighborhood problems, and it doesn't look like it's a fun place to be for them, and people sort of naturally start to gravitate away from that. So we see some real changes there. But then we look at issues like marijuana. And again, the prosecutor would say, well, you're concerned about these offenders clogging up the prisons. Yes, it's true there are maybe 20 or 30,000 people in state and federal prison for a marijuana offense. Most of these are there for relatively high levels of selling marijuana. We could debate whether or not they should be locked up for that, but they're not taking up most of the space in prison, certainly. But we do know with 700,000 or 800,000 marijuana arrests every year, the amount of law enforcement resources, court resources going into processing people through the system is quite enormous for marijuana. Resources are finite, so every time a police officer is making a marijuana arrest, every time the court is processing someone, there are other public safety concerns that are not being addressed at that time. So it's a question of public safety, it's a question of resources, how we balance things out, whether or not our federal and state prisons are filling up with marijuana offenders. The recent ACLU report shows the great racial disparity in marijuana offenses around the country, very much out of line with the degree to which people of color use or sell drugs, as we've seen with other drug offenses as well. The next argument the prosecutor's making that all you reformers are talking about these low-level offenders in prison, and actually most of them are sellers. This is correct. You know, whether it's marijuana or other drugs, you don't go to state or federal prison merely for possessing or using drugs very often. You know, if you look at the data, most people in prison, they're for trafficking offenses. Even when it's called possession, it's often possession with intent to deliver, which in effect means that they think you're a drug seller as well. So most people locked up for a drug offense are there for selling drugs. Further, many, if not most of these people have prior convictions either for drug offenses or for other offenses. So it seems to me we need to be very strategic in how we frame our arguments on these questions. If we consciously or inadvertently give the impression that people are sitting in a prison cell because they like to get high on Saturday night, I think that's not going to get us very far. So what do we know about these people in prison? Well, we do know that the vast majority of them are not the so-called kingpins of the drug trade. We know that we have research from the U.S. Sentencing Commission, research on people in state prisons as well. Probably half or more of the people in prison for selling drugs are in the lower levels of the drug trade, the street corner sellers, the couriers, the mules, people like that in terms of their functions in the drug trade. Now, what does this mean in terms of public safety? Well, if you look at the impact that we have on public safety by sending people to prison, when it comes to locking up people for selling drugs, what we see is what the criminologists would call a replacement effect. So that is, somebody gets locked up for a rape or a robbery or something like that. We've isolated that person from the community. We brought some measure of safety by keeping the person separated from the community. When it comes to drug offenses, particularly if we're talking about the street corner sellers and other people of that level, those people arrested, sent away to prison, as long as there's a demand for drugs in that community, they will inevitably be replaced, and usually rather quickly, to meet the demand for drugs. So when we lock these people up in enormous numbers, we haven't necessarily done anything about the drug trade on that street corner, but we have done a lot in terms of spending public money, breaking apart families, diverting our resources from other ways that we might address some of the drug problem. So we don't see much happening there. Then finally, the argument about racial disparity in the prosecution of the war on drugs. And here, again, the argument is, well, if some groups are in prison more so for certain types of crime, we have a set of race-neutral policies, sentencing policies and otherwise. If you do the crime, you do the time, and that's too bad, but that's kind of the way it is how the argument goes, which I think really ignores the role of discretion, ignores the role of racial perceptions in policy and practice, and how these factors play themselves out in particular. If we look at the broad level of criminal justice sentencing policy, again looking at something like crack cocaine, here in 1986, there was a real problem with this new drug, crack cocaine. It was doing real harm to people, just as other drugs had done too. And at the federal level, Congress was faced with the challenge of how to respond to this drug. Well, there are many different ways that they could have gone about doing it. They could have looked at what we knew about the history of the drug, the use of the drug, who was bringing the drug into communities, what kinds of prevention or treatment strategies might be appropriate in dealing with the drug, and to the extent that we viewed it as a criminal justice problem, what kind of law enforcement resources or sentencing structures would be appropriate. None of that conversation took place. Instead, there was just a rush to pass very harsh mandatory sentencing policies. These policies, I like to say, were adopted in about 20 minutes, and it took us 20 years to finally get any kind of scaling back of the policies too. We then immediately saw about 80% of the people charged with these offenses were African American. And just to point out, as tragic as the laws, the sentencing laws were themselves, that didn't produce a defendant population. It was 80% African American. That was a law enforcement strategy. Who was brought in for these kinds of drug cases, what decisions were made by law enforcement in terms of how to prosecute the war on drugs. We see it at the level of prosecution, charging, plea negotiations. Reports from the U.S. Sentencing Commission show us on mandatory sentencing, the big secret is mandatory sentencing is not always mandatory, despite what the legislators may believe. Discretion by prosecutors results in many defendants avoiding the mandatory penalties, and we also see great racial disparity in how that plays out. So white defendants are able to avoid the mandatory much more so than black defendants are. A lot of factors, both conscious and unconscious, go into those decisions, but that's how that plays out. Finally, the argument that, well, this is what communities of color are demanding. They have real problems. Grandmothers say they want to see their school children coming home from school in a safe manner, not have to go by drug dealers on the corner. We need to do something. People in every community don't want school kids coming home having to pass drug dealers. Nothing unique about communities of color there. What is going on is that we're seeing is a set of decisions made by practitioners and policymakers to say, okay, you've got a drug problem in your neighborhood, we will take care of that. We'll give you police, we'll give you prosecutors, we'll give you prisons. That's how we'll deal with that problem. I don't think they're listening very carefully. I don't think people are saying in communities of color or majority communities or any others, that's what they want. I think they're saying, we want to do something about public safety in our streets. If you have a conversation with any community, you will get a very robust discussion about the variety of ways that safety is produced by having good jobs, good schools, good health care, and yes, also a good criminal justice system. So it seems to me we've taken a very narrow vision of what public safety looks like and how it's achieved, and that's become our national strategy. So in closing, let me just say, I would agree with the other speakers this morning, we are at a moment of possible reform now. I think the national conversation is beginning to shift in a much more constructive direction. At the same time, it's important for us to keep very clear about the scale of the problem. I'm very concerned with the numbers of people in prison. The last 3 years or so, we've seen a decline of maybe 1% a year in the national prison population. With 2 million people behind bars, 1% a year is not going to get us there very quickly. So we need to take a much more sustained, much more aggressive, much broader approach to how we can achieve some meaningful reform and take advantage of what I think could be a very important opportunity now. So thank you very much.
Thank you, Marc. To follow up on the first presentation, we're going to have some information now about how police surveillance and the use of police discretion within communities of color result in the kinds of overrepresentation in the imprisonment and correctional environment.
So first, my name is Dwayne Nash. I'm from Northwestern University. I'm a PhD candidate currently. I'd like to thank Columbia University as well as the Schomburg and my esteemed colleagues for presenting their wonderful work and for this opportunity to share with you my research on the origins and social impact of stop and frisk law in New York during the 1960s. So stop and frisk authorizes police to stop, question, and search individuals, citizens, without a probable cause or a warrant. It poses major civil liberties issues. It strips citizens of their Fourth Amendment rights to be free from unreasonable search and seizures. It also is legal methodology originating from reforms to New York's criminal procedure law. It went into effect one day before Congress passed the Civil Rights Act of 1964, and that's not by any surprise, I argue here. It has led to mass criminalization, which in turn became effective because of mass arrests during this time. There is a form of historical amnesia around this origin and this early history. Historians of the civil rights movements and in general historians have failed to investigate the origins of stop and frisk and other unjust criminal procedures laws that were passed during the civil rights movement, especially when several black rights were won. So what is the results of these unreasonable searches? As a former prosecutor, I had firsthand knowledge of the racial bias built into the enforcement of stop and frisks. Currently, within the past year, police stopped over 500,000 individuals on New York City streets. The racial impact of this was 87% were people from Black or Latino communities, although within New York City, only 23% of its population is Black and 29% is Latino. The effectiveness of these current searches and stops was 89% of these people were innocent. Less than 9% were arrested at all, and less than 1% of these people had weapons. So what was the consequence? The overall consequence of these stops was an enormous amount of arrests for marijuana, simple possession of marijuana. Over 50,000 people in New York City were arrested per year by marijuana. And scholar Harry Levine has done wonderful research on this, looking at marijuana arrests for the past 35 years. My research does a historical depth to this contemporary social problem. Most scholars that look at the widespread use of stop and frisk often attribute it to former New York City Mayor Rudolph Giuliani, who during the 1990s encouraged police to aggressively use stop and frisk against low-level crimes under the belief, based on a sociological study called the broken window effect, that by policing low-level crimes, then you would stop more serious crimes. However, when scholars began to look at the racial disparity of these stops, they attributed it to the war on drugs during the 1980s when President Reagan began this war. During the 1980s, federal government and federal police officers, law enforcement agents, were specifically trained to use race as a method of detecting suspicion. So using race specifically to determine who to stop and search on highways and airports and in neighborhoods. Also, these federal agents also trained state law enforcement agencies. However, what my research does is it takes the history of stop and frisk further back. And we see that I discovered that in 1964, the then governor, Nelson Aldrich Rockefeller, a liberal Republican, proposed a war on crime much earlier than Nixon's war in the 1970s. And also his war on crime, in a speech that he gave before New York State legislature, he proposed a new criminal procedure law, which was stop and frisk. This law was the nation's first statute to use such novel language against giving police the rights to stop and search individuals. And that new language replaced the constitutional requirement language of probable cause. It made a lower standard for police to search individuals based on reasonable suspicion. This happens well before 1973, when Rockefeller proposes his minimum standards for minimum sentences of 15 years to life for people that were drug offenders. Most scholars that look at the Rockefeller drug laws, they say, or they assume that this was a sudden change in his policies to go from rehabilitating drug addicts to suddenly punishing them. But what I argue is that this was not sudden, this was a gradual movement toward this. And if you look at what he proposed for more punitive damages, for more punitive policing through stop and frisk law, then you can see how the state of New York starts to move more and more closer to a more punitive punishment for drug abusers. So I ask in my research 3 basic questions. What motivated New York State to pass this new legislation? How did the very large black communities in New York respond to this? And also, how did black communities and activists respond to this new law during the heroin epidemic that began in Harlem in the early 60s? My findings are that Rockefeller claimed that stop and frisk was needed to combat violent crime. However, during 1964, when he proposed it, violent crime was relatively low. It had been the same as it had been in 1950s. So his motivation was not a violent street crime. At the time, his main motive was to reverse liberal Supreme Court decisions that gave more rights to criminal defendants. And that the #1 case was Mapp versus Ohio, which I'll talk about in this presentation. This was an opinion in 1961 that gave criminal defendants more rights in courts. He also did it for, what I argue, political economy. Rockefeller ran for president 3 times during, from 1960 to 1968, and being tough on crime had political coinage. It would allow him to align himself with more radical Republicans on the right, as well as Democrats that were concerned for safety. However, there were other incentives. New York City Police Department saw stop and frisk, saw some incentive to use stop and frisk. What their intentions were: 1, they enforced it largely in black and Latino communities in New York. Second, they used it to surveil and control and commandeer civil liberties activists and other citizens. The unintended consequences of this was that it was used to draw national attention to the drug epidemic in New York that took place. So here's a little bit about Mapp. As you can see, this is the Chief Justice Warren, who was head of the Supreme Court. What Mapp stood for the first time in history, the Supreme Court applied the 4th Amendment to state courts. And this meant that, that police could no longer just simply stop and search individuals. It required police to have probable cause to first arrest and then to search individuals on the streets. The court also created an exclusionary rule, which meant if police did not have probable cause, then any evidence that was recovered from individuals as a result of these unlawful stops would be not admitted in court. They would be dismissed from court. The rationale of the court was to deter police from searching people on a mere hunch of suspicion. Well, what was the aftermath of this MAP opinion? As you can see, this is the plaintiff in the case, Delores Mapp. She was a mixed-race woman, African-American and Cherokee, a single mother, and living in Ohio in a segregated, in an all-white city section of Ohio. What law enforcement had said was that the MAP decision handcuffed police from doing their jobs. As a result of this opinion, prosecutions reduced significantly for gambling by 35%, and for drug convictions in New York from between 1962 to 1964 reduced by 40%. Post-1964, when stop and frisk went into effect, of course, there's an increase in arrests now. Suddenly, there is 20% increase in arrests. There's overcrowding of jails. And from 1964 to 1969, over 6,000 inmates are removed from overcrowded local prisons and sent to state facilities. One of the prime individuals supporting stop and frisk was then Police Commissioner Michael Murphy. He had it against, he was adamantly against civil rights protesters and anyone protesting in a black community. There's a quote above where he says, "We will not allow civil rights leaders to turn New York City into a battleground." And he used stop and frisk aggressively to search and find some form of criminality from individuals on the streets. However, there was some support from black conservatives. Not many, but some, and one person was the Reverend Obadiah Dempsey. He was mayor of Harlem for a short period of time, but he also established the Anti-Narcotics and Anti-Crime Committee right here in Harlem from his church. And as you can see, his Upper Park Avenue Baptist Church, which he established in 1962, bore all of those signs directing drug dealers to get out of Harlem. He began, in essence, an early citizens' war against drugs. At the time, in the 1960s, the Federal Bureau of Narcotics had estimated that over 25,000 black people were addicted to drugs across the nation. However, what Dempsey and the black press had claimed at the time was that there was almost 50,000 black addicts in Harlem alone. Dempsey had joined the Rockefellers' war on drugs and gave Rockefeller a compelling argument for stop and frisk and being a little more aggressive with drugs. Some scholars argue that Dempsey represents a black punitive popularism, meaning that he represents a faction of the black community that was for punishment and punishing drug users. There was resistance from the black community and overwhelming resistance. Black politicians such as Constance Baker Motley, was in a local senate at the time, and she was against stop and frisk. She tried to stop it. But when black representatives were unsuccessful, black normal people in their everyday lives had ultimately there was a riot in 1964, but they had protested and demonstrated all throughout New York, even took over the police station in 1964. They also challenged in court stop and frisk. And the seminal case for stop and frisk is Terry versus Ohio. What most scholars and even legal practitioners don't realize is that Terry versus Ohio is not just a case about Ohio. It was a trilogy. So there were two cases attached to Terry. There are two cases attached to Terry, and two of them, those two, are from New York. And one of them is Peters versus New York and Sabran versus New York. Sabran actually dealt with drugs. In essence, the Supreme Court in an 8-to-1 opinion ruled completely in favor of the police in all 3 cases, and also adopted the language of reasonable suspicion that the New York statute, stop and frisk statute, had actually espoused. Today, this means that 50 years later, we still have stop and frisk. It's still very good. It's still good law. It's still constitutional. And I'm going to leave you with a short clip from The Nation, which shows you about the subjectivity that blacks and Latino youth in New York City are subjected to as a result of this law.
I was walking home from
It's only a minute, so.
And a cop car went past me. A couple of seconds later, I heard the car turn around, and they just popped out. They just all jumped out the car. I decided to record it because I was getting stopped a lot, and I didn't have evidence of cop being disrespectful or anything, so I pressed the button and recorded the whole thing.
Oh, you again, man.
Yo, I just got stopped like 2 blocks ago, yo.
You look very suspicious.
Cause y'all always looking at me crazy.
Because you keep looking back at us, man.
Cause y'all always looking crazy, yo. Coming up the block, always.
That's our job, man.
To stare at me, yo?
Listen to me. Listen to me. Our job is to look for suspicious behavior. When you keep looking at us like that, looking back.
Cause y'all always like stop. I just got stopped like 2 blocks away. Like.
People don't like police because of the harassment. And what civilians don't understand is that the police department is like forcing us to do these unreasonable stops, or you're going to get penalized.
I had this captain who walked into the precinct and gave a speech about harassing the public. His words were, we're going to go out there and we're going to violate some rights. We hear it from the captain down. We want 250s. This is stop, question, and frisk.
Mouth, kid.
What am I getting arrested for?
Shut your mouth.
What am I getting arrested for?
For being a fucking mutt, you know what?
Also, that's a law, being a mutt?
So he grabbed me by my book bag, and he started pushing me down. So I'm going backwards, like down the hill, and he just kept pushing me and pushing me. It looked like he was gonna hit me. I felt like they were trying to make me resist or fight me back.
Thank you, Dr.
So
Nash.
thank you.
And for those of you who haven't seen that entire video, it gets or heard that audio, it gets a lot worse than what you saw today. So now we're going to hear the consequences of once a person is drawn into the system, how prosecution takes place in relation to the war on drugs.
Thanks,
Thank you,
Delores.
Whitney.
That was so powerful. Thank you for sharing that. Okay, my name is Whitney Tymas. I direct a project at the VERA Institute of Justice, and I actually, for those of you who aren't familiar with VERA, it's a nonprofit, nonpartisan organization. It's 52 years old, and it's focused on criminal justice reform, essentially. Our programs and centers span across the nation and across the world, and they focus on things like youth justice, sentencing and corrections, family justice, let's see, immigration, international issues. So it's a very broad-reaching organization. The program that I direct at VERA is the only program at VERA that emphasizes race specifically. It's the only program that has as its mandate achieving racial justice. And so I actually started out as a baby lawyer 23 years ago at another VERA project, working as a public defender here in Harlem at the Neighborhood Defender Service of Harlem when the doors opened at NDS, and went on to work at Legal Aid as a defender, doing appeals at the Office of the Appellate Defender. I worked as a defense attorney for quite a long time, and then moved to the South and became a prosecutor. I worked for a young prosecutor who's the first African-American elected in the city that I lived in, and he was progressive. And so my experience has been pretty across the board. If I can leave you all with one message today, and I'm so glad that Marc was emphasizing prosecution. The message that I'd like to leave you with is this: no one in the criminal justice system has more power than prosecutors. No one exercises greater discretion with less oversight. And so for years and years, the public was focused on policing, which is very important, also focused on judges. There were sentencing guidelines that were enacted to constrict the discretion of judges. Police departments across the country were being sued. Everybody remembers Rodney King. That propelled forward a lot of litigation around policing, but prosecutors for decades flew under the radar, and nobody knew what prosecutors were doing, how prosecutors were making decisions, why they were exercising discretion in the way that they were, and that's beginning to change. The program that I'm privileged to direct at VERA is actually the first time that an organization has strategically and comprehensively looked at the prosecutorial function and kind of broken it down to see how it is in particular prosecutors' offices that folks are making decisions. So that's what I'm here to describe for you today very briefly. So let me get into that. So the Prosecution Racial Justice Program, I'll just call it PRJ for short, it started in 2005. And I was joking with Marc about this. When this program started, it was unclear whether anybody was going to work with us, because the goal of the program is to advance racial justice by partnering with prosecutors to go into their offices and basically audit them, to look into their files and to look at every place where prosecutors are exercising discretion. And that's a lot of places, folks. I mean, prosecutors start making decisions when that case walks in the door. Prosecutors decide, are we going to keep the case or not? If we're going to keep it, what charges are we going to file? Are we going to decrease the charges for some people and increase the charges for other people? How many charges are we going to file? Then, what kind of bail recommendations are we going to make? Are we going to allow some folks to be released? Are we going to consent to releasing some folks on their own recognizance versus asking for bail for other people? Later on, what types of pleas are we going to offer, et cetera? I mean, it goes on. And at each one of these stages where prosecutors are exercising discretion, they're doing so in an unfettered, unexamined way. I mean, you don't hear about prosecutors getting sued, do you? No, I mean, it's virtually impossible through legal action to hold prosecutors accountable for the decisions that are made. And so this is why I loved Marc's emphasis on prosecutors, because nobody talks about what prosecutors are doing, but nobody's got more power than prosecutors. So I hope you all will walk out of here with a greater appreciation for that. So let me just talk to you a little bit about, I guess in terms of what I'd like to tell you about, my outline would be to talk a bit about the need for more research into prosecution and race, what our mission is with PRJ and what our model is and our methodology for getting the work done, and give you some examples of what we're doing, and then we'll open up the floor for questions later on. But, all right, so in terms of an introduction to this program, I just want to say this. I mean, I think most prosecutors' offices are functioning as if we were living in a post-racial society, but we're not, okay? Prosecutors do not get trained to think about race, to talk about race, to examine how race is implicated in all of the decisions that are being made in their offices every single day. And I can tell you that when I was a prosecutor, frequently my colleagues would come into my office and we would shut the door and we'd have these conversations kind of on the down low that went something like this: what are we going to do? You know, we didn't know. And these were always African-American colleagues. And that's not to say that my white colleagues who were progressive weren't having similar conversations, but the fact is there was no forum for having discussions about race, and we had no training or no tools with which to understand how we were implicated directly in the injustices that we were seeing, that were being perpetrated in court every single day. But you couldn't miss it. I mean, it was blinding in its obviousness, really. But we didn't know what we could do about it and how deeply implicated we were. And so that's what the Prosecution and Racial Justice program is designed to address. People talk about prosecution as being this black box. And you know, the black box that's in airplanes, if the plane goes down, then everything is destroyed but the black box, because the black box is impenetrable and nobody can get inside of it. It contains all the secrets, right? Okay, that's a great, great analogy for prosecution. You can't see what's going on from the outside. And it's also a good analogy from another perspective, because you really can't see what's going on from the inside either. I mean, the people in the box don't understand what the contours are of the box without some help. And so that's what our goal is to shed some light on the contours of the decision-making that's being done in prosecutors' offices. So in terms of the need for research in this area, there really are not comprehensive studies out there that focus on prosecutorial discretion in a broad way. I mean, there are some empirical studies. PRJ has done a literature review that kind of outlines 32 empirical studies that relate to prosecution and race, but those studies typically they would look at one aspect of prosecution. They might look at charging, or they might look at plea bargaining. Actually, there's been very little research on plea bargaining, but you know, they might look at one piece or another, but there's really nothing out there comprehensively to talk about prosecution in a meaningful way. And so so that is another reason why there's a need for this type of work, the type of research that's being done by VERA. And also, prosecutors' offices don't typically capture data. When I was a prosecutor, I think my office was very typical in the sense that we had some rickety file cabinets, and that's where we kept our files. We didn't have a case management system for years and years, and I can confess, I hope that I'm among friends, that I was very backwards, you know, when it came to recognizing myself the import of keeping track, of counting decisions, the decisions that were being made in the office, so that in the aggregate we could see if there were real problems that were going on. And so this is a new frontier for prosecutors, even having data management systems at all that will tell them what they're doing in any meaningful aggregate way. So that's another reason why there's a need for partnerships that put researchers in contact with prosecutors to give them greater understanding. You know, I'd also say this: there's a disconnect between research and prosecution. It's very unusual that a prosecutor's office would have researchers come in and analyze files and do this type of work. Data on prosecution is very sensitive data, but when you add race to the mix, it's even more sensitive. And so it's really been a challenge, you know, getting the work going, enlisting the trust and support of our partners so that they will let us go in and pull, you know, thousands and thousands of files and start cranking numbers to see how they're exercising discretion in the aggregate. So I should just give you some examples of the type of work that's going on. We've been in several jurisdictions, Charlotte, North Carolina, which didn't have any data management system at all when we got there, and we had to come in and build a system for them. We were working specifically on drug cases in Charlotte because that's where most of the data was held. So that's why we focused on drugs. That was a very heavy lift. San Diego, California was another partner. Milwaukee, Wisconsin, I don't know if you all know this, but Wisconsin incarcerates African Americans at a higher rate than any state in the nation. And so we were invited into Milwaukee to work with them. We are now in Manhattan, and we are about to release findings that are the culmination of 18 months of research in Manhattan. We had a data set that was over 200,000 cases, huge data set. We looked at every discretion point. We looked at every kind of case. The work was funded by the National Institute of Justice, and I will say that I'm really heartened that the feds are starting to acknowledge the profound racism in the criminal justice system. I don't know if anybody heard Eric Holder's speech, but it was like a watershed moment to hear the Attorney General say that we are in the midst of an unjust and an unsustainable status quo. And I mean, people talk about how the status quo is unsustainable because it's expensive as hell, but nobody says that it's unjust. And to hear him say that it's unjust and to reference racial disparity was just absolutely, I mean, it was very, very different. And so the work that we're doing in Manhattan is funded by the National Institute of Justice. They gave us close to $500,000 to work for 18 months in that office, to look at all different discretion points. As I said, over 200,000 cases. The way the work is done is that we look at all the places where prosecutors exercise discretion. We look at all of the types of cases where that discretion is exercised, drug cases, violent crime, property crime, and then drill down deeper, and within these broad offense categories, look at specific offense categories. So within the context of drugs, for example, we would be looking at not just at possession, but possession with intent. We paid particular attention to marijuana cases. So we're looking at very specific subcategories of cases and drilling as deeply as we can to see where there's disparity. So that work is going to produce a report that the public will see in the next couple of months, so please stay tuned for that. We're about to expand into San Francisco. And also into Nebraska, which is a very tiny office, and I think that methodologically we're going to learn a lot about how you work with small prosecutors' offices, which are really typical of most prosecutors. Most of the 2,300 state and local prosecutors' offices are small. So, so let me just sit down and be quiet. Thank you very much, and I look forward to your questions.
Thank you so much. So our next presenter is going to talk to us about the employment consequences of contact with the criminal justice system. So tell us who you are and your connection to this work.
Sure. So good. It's officially afternoon. Good afternoon.
Good afternoon.
Kimani Paul-Emelie. I teach at Fordham Law School. I teach and research in the areas of drug regulation and healthcare law, among others. And today I'm going to talk a little bit about employment discrimination against people with criminal records. I'm going to lay the background out a little bit. Then I'm going to talk about the existing legal framework used to address this type of discrimination. And then I'm going to propose an alternate framework that's based on healthcare laws. So obtaining someone's criminal history information is one of the easiest things you can do online today. All you need is a computer, a valid credit card, someone's social security number and name, and a couple minutes to spare, and you're off to the races. And this will give you access, virtually instantaneous access, to the more than 93 million computerized records available online today. And this represents more than 30% of the American population. Now, just a few decades ago, criminal background checks were very difficult to do, and this is largely because you had to search the relevant court or government agency where the records might be, and this took a lot of time. And if the person you're searching, if you have a sense that they might have records in various states, you might have to visit each and every state. As a result, background checks for employment were typically reserved for people in high-ranking or sensitive positions. But today, tens of millions of criminal searches, background searches, are conducted each year through companies in the multi-billion-dollar criminal background check industry. Now, those most likely to conduct searches are insurance companies, landlords, and importantly for our purposes today, employers. Now, getting a job in this economic climate is difficult, but it's particularly hard for people with criminal records. And that's because over 90% of employers, including Walmart, the nation's largest private employer, conduct background searches on their applicants. And nearly 3/4 of all employers have adopted blanket hiring prohibitions against people with criminal records. And these employers include such nationally recognized companies as Bank of America, Lowe's, Domino's Pizza, and many employers even bar people with just a record of an arrest. And this affects a lot of people. Nearly 1 in 3 individuals now living in this country has had some involvement with the criminal justice system that would turn up in a routine background check. In raw numbers, that's 68 million people. The overwhelming of these violations are for minor or nonviolent offenses such as curfew violations, loitering, vagrancy, disorderly conduct. And records often consist solely of an arrest that didn't lead to a conviction. Yet this information can end up in a criminal background check or criminal history report and can be used to deny someone a job. And this has a disproportionate effect on people of color because they're overrepresented in the criminal justice system relative to their share of the population and relative to their involvement in criminal activity. So for example, African Americans are 15 times more likely to be arrested than whites for low-level offenses, while Latinos are 3 times more likely than whites. And this is due, as Dwayne mentioned, this is due largely to aggressive policing strategies that target minority communities, such as stop and frisk, broken windows policing, the war on drugs, as Marc mentioned. And all of these have become popular among urban police forces over the last couple of years. And I'm sure you're all familiar with the recent lawsuit against the NYPD, the successful lawsuit against them for their unconstitutional stop and frisk practices. But not only are people of color more likely to have a criminal record, but for this group, having a criminal record is significantly worse than for whites. So for example, groundbreaking audit studies conducted by researchers at Harvard and Princeton universities found that whites with a criminal record were half as likely to get a job as whites without a criminal record. And blacks with a criminal record were 1/3 as likely to get a job as blacks without a criminal record. But what's disturbing is the research also revealed that whites with a purported recent felony conviction had a 40% higher chance of getting a callback than blacks without a record, okay? And similar patterns have been found between whites and Latinos. And these findings suggest that for people of color are particularly stigmatized by having a criminal record, and in fact suffer what scholars call a criminal records penalty. Now, the fact that employers have virtually unlimited access to criminal history information only intensifies this stigma, making it all but impossible for minority ex-offenders or minorities with criminal records to find gainful employment. So what are the current laws used to address this problem? The current laws that curb or that govern employers' use of criminal records in employment are Title VI of the Civil Rights Act of 1964 and the Fair Credit Reporting Act, okay? But as I'll explain, neither law adequately protects the interests of employers, potential employees, or the societal interest in having people working. And here's why. I'm going to start with the Fair Credit Reporting Act, which I'm going to refer to as the FCRA. The FCRA is the primary federal law governing the collection and distribution of consumer information for employment, including the dissemination of criminal history information, disseminated by criminal background checking companies, commercial companies. Now, this law has 2 major components. First, it requires employers to notify a potential job candidate, or to get consent from a potential job candidate before conducting a search. And second, it requires employers to notify a potential employee or a job candidate before excluding them from employment based on a record that was found. Okay? But neither of these provisions are adequately enforced. What typically happens is, employers get an application, they do an online background check without the applicant's consent, and if they find a record, they never call the person back. Now, on top of this, the FCRA is supposed to ensure that the information contained in criminal records is accurate, but it fails to do that too. Numerous studies show that criminal history reports are riddled with errors and frequently contain significant inaccuracies. For example, they often contain misspellings or clerical errors, which lead to false positive identifications and false negative identifications. And there are other types of errors as well. For example, they often release, criminal history reports often release information that should have been sealed or expunged, and they frequently include missing case disposition information. So for example, if your felony was reduced to a misdemeanor, or if all the charges were dropped, often those updates don't make it into the criminal history report that's circulating out there and that employers are searching. And it's estimated that hundreds of thousands of these errors occur each year. And this rate of error translates into huge numbers of people being denied employment opportunities. And erroneous reports can circulate indefinitely, and the applicant may never know why they were denied a job. So that's the FCRA. Then there's Title VII of the Civil Rights Act, which prohibits discrimination on the basis of race, color, religion, sex, and national origin. It also prohibits employers from automatically denying employment to people based on an arrest or conviction record. This is because blanket prohibitions on the hiring of people with criminal records are likely to have a disproportionate effect on people of color because they're statistically more likely to have a criminal record. However, in a criminal records discrimination case brought under Title VII, even if a plaintiff is successful in proving that an employer's policy had a negative disparate impact on someone of color, the employer can still prevail so long as they're able to show that their policy of rejecting people based on criminal records is job-related for the position in question or is consistent with business necessity, okay? So that's Title VII. Seems like a fairly reasonable framework, but as I'll explain, Title VII, when applied to criminal records discrimination as opposed to straight race discrimination, produces really unique problems that make it incredibly difficult for people of color with criminal records to get hired and to challenge adverse employment decisions. And this is due to several factors. First, Title VII was enacted to target race discrimination, but criminal records discrimination isn't completely analogous to race discrimination. This is because the central focus in most race cases is on whether the employer was unlawfully motivated by the employee's race when making a decision. And this is due to the fact that race is generally understood as being irrelevant to a person's ability to do a job. Criminal history information, on the other hand, is occasionally quite relevant to hiring. So, for example, consideration of a recent embezzlement conviction might be relevant if you're hiring a bank teller or an accountant, but consideration of a loitering conviction might not be relevant when you're hiring a bus driver. So under Title VII, employers can lawfully consider a job applicant's criminal history information, but this can raise problems because an applicant's race may consciously or unconsciously negatively influence an employer's evaluation of a candidate's record. And this makes detecting invidious discrimination very difficult. Another problem with the Title VII framework is that criminal records discrimination happens very early in the hiring process, when job applicants often have little explicit knowledge of why they were denied a job or an interview, and may never know the real reason for their rejection. And this limits their ability to challenge the employer's discriminatory actions. And finally, neither Title VII nor the FCRA addresses the ways in which the combination of a criminal record and minority status produces a distinctive and powerful social stigma that studies show is significantly more detrimental than minority status or ex-offender status alone. For these reasons, neither Title VII or the FCRA prevent or redress invidious discrimination effectively in this context. Now, to more effectively address these problems, I propose conceptualizing criminal records discrimination through a health law framework, specifically through the lens of the Americans with Disabilities Act, the ADA, and through the Genetic Information Non-Discrimination Act, which I'll refer to as GINA. So the ADA prohibits discrimination against people with disabilities, and GINA prohibits employment discrimination based on genetic information. I argue that there are aspects of these laws that offer a better way of understanding and curbing the discrimination that results from membership in a minority, ethnic minority or racial minority group and having a criminal record. And this is because despite their similar goals, Title VII, the ADA, and GINA all differ from conventional, well, the ADA and GINA differ from conventional race discrimination law in important ways. First, having a disability, like having a criminal record, is relevant to employment decision-making and can be used as a permissible grounds for excluding an individual from employment, and this is never the case with race. Second, in contrast to Title VII, both the ADA and GINA were designed to target discrimination based on a trait or condition that's not visible, but which carries a very strong social stigma, that can form the basis of an adverse employment decision. And third, because employers are allowed to consider potentially stigmatizing information about employees, and job candidates in the health law context, as in the criminal records setting, the ADA and GINA have developed doctrinal schemes or legal mechanisms that regulate the flow of stigmatizing information in order to prevent discrimination preemptively. So how does this work in practice? Under the ADA, an employer can't attempt to learn whether an applicant has a disability prior to making a job offer. And the goal here is to allow people with disabilities a fair opportunity to be judged on their qualifications. Then, however, once a job offer has been made, but before the candidate begins work, an employer may ask disability-related questions. However, if an individual is denied a job because these questions reveal a disability, then, like under Title VII, the employer has to demonstrate that this exclusion was job-related and consistent with business necessity. As applied to the criminal records context, employers should be precluded from requesting, acquiring, or purchasing a job applicant's criminal records until after the pre-offer phase. And in keeping with GINA, which prohibits access to stigmatizing genetic information online, here in the criminal records context, it should also preclude employers from accessing commercial records during this period. Now, this health law framework would allow individuals with criminal records to proceed past the phase at which an employer is most likely to use their stigmatized status as a basis for an employment exclusion. And this doctrinal scheme would also make it easier for former offenders to prove intentional discrimination because it forces an employer to articulate a justification for rejecting a candidate after already approving them. In addition, it enhances the FCRA to the extent that preventing employers from getting information about an individual's criminal history criminal history information during this pre-offer phase would allow for more robust enforcement of the FCRA to the extent that requiring employers, it would allow requiring employers to obtain a job candidate's consent prior to conducting a background check would be easier to police. It would also enforce or give teeth to the FCRA's mandate requiring the notification of employees before an adverse employment decision is made on the basis of their criminal record. Now, in addition, the health law framework would alleviate the problems caused by the pervasive inaccuracies that now plague criminal history reports. For example, it would give job seekers an opportunity to explain, rebut, or check the veracity of a record being considered before they're disqualified for employment. It would also give a job candidate the opportunity to catch a conviction record that should have been expunged, or a felony offense that was subsequently reduced to a misdemeanor, or some other error in the record. Now, employers often say they don't want to hire people with criminal records because doing so might increase their liability, their tort liability for things like negligent hiring or negligent retention lawsuits if the employee were to commit a crime at the office or at work, like fraud, theft, or violence. In the ADA and GINA contexts, employers are similarly concerned about increased health care costs or other costs that may be imposed by hiring someone with a disability or someone with a predisposition towards developing a genetic predisposition to developing a disease. Still, under GINA and the ADA, the expectation is that the employer will assume the risk. Here, the ADA's reasonable accommodation mandate is instructive. Under the ADA, an employer can't refuse to hire a job candidate based on a marginally increased risk or speculation about future risk or an assumption about the disability. An employer must also consider whether a reasonable accommodation can eliminate or reduce the risk. If the requested accommodation causes undue hardship, which is to say whether it would require substantial difficulty or expense, the employer would still have to provide another accommodation that doesn't. Hence, the reasonable accommodation mandate is an explicit recognition that the employer is best able to bear the potential costs associated with hiring a disabled applicant. And this, I think, should apply in the criminal records context. But also, in the criminal records context, the assumption for many employers is that people with criminal records are at a high risk of committing future crimes. But data reveals that once those with criminal records have stayed clean for a few years, their chance of being rearrested virtually disappears. And this point is widely referred to as a point of redemption. It averages from between 3 and 7 years, depending on the offense or the age at which the arrest occurred. And in addition, studies show that those with criminal records are less likely to commit a crime at work than those who've never been convicted. Now, this is not to suggest that there are no risks, I'm going to wrap up, that there are no risks involved or associated with hiring former offenders, which, like all hiring, involves some element of risk. However, employers are best able to assume the costs and risks associated with the hiring process, and they're better able than those people applying for the jobs, particularly people with criminal records. Plus, as with the disabled, the social cost of failing to facilitate employment for this population are tremendous. Many people with criminal records are the primary wage earners for their families, so employment discrimination in this context has significant third-party effects. Moreover, people with criminal records who've spent time in jail and who were jobless after reentry were 3 times more likely to return to prison. And today, incarceration expenditures, as we've heard in the first panel, cost taxpayers $56 billion annually. And we do know, though, that stable work is the single most effective way of protecting against a return to criminal activity, reducing recidivism by as much as 40%. And as Dr. Roberts mentioned earlier, what's particularly important is that this type of discrimination denies opportunities to those workers who may be best qualified for the job. And this hurts the employers, the employees, and all of us. So the reasonable accommodation mandate is about the allocation of costs, but it's also an explicit recognition that removing these barriers is an essential means of reducing social marginalization and ensuring. Now, having a criminal record is not entirely analogous to being disabled or having a genetic predisposition, to the extent that one is born with a disability and one ostensibly earns a criminal record. But that's not always the case, particularly for people of color with criminal records. Indeed, 1/3 of people of color with criminal records have never been convicted of a crime, as many criminal records contain only arrests that never led to conviction, and such arrests are most likely to occur in minority communities. For example, in New York alone, nearly 750,000 people were stopped and questioned by the NYPD, and 87% were Black and Latino, and only 9% were white. But nearly 90% of those who were stopped had done nothing wrong, but these arrests can find their way onto a criminal history report. And such practices have been shown to be quite widespread. 1 minute. For example, wrapping up, just last year, the ACLU brought a lawsuit against the NYPD for stopping and ticketing or arresting people in their own buildings if they weren't able to show ID as they walked through the hallways and to take out the trash or to get their mail, et cetera. So while some bit of stigma might be appropriate for some offenses, and not every offender is well suited for every type of job, people should be entitled to a second chance after paying their debt to society. They shouldn't be automatically denied opportunities to compete for legitimate employment. They should be able to support themselves and their families, to pay their taxes, to make a positive contribution to their communities and societies. And people shouldn't suffer a lifetime employment penalty for an unsubstantiated arrest, a youthful indiscretion, a minor infraction, or a more serious offense that happened in the distant past. Yet this is exactly what's happening, and it's compounded for people of color due to this employment penalty. So in conclusion, the health law model that I propose here tries to balance the interests of both employers and employees, along with the social and economic costs. And in so doing, it enables the existing Title VII framework and the FCRA framework to more effectively guarantee equal employment opportunities for former offenders, protect safety and security in the workplace, and promote the broader societal interest in ensuring legitimate employment opportunities for people with criminal records. Thank you.
Thank you. And I think our final paper will provide an appropriate sort of contrast or give us an understanding of why the suggestions that have been made by Dr. Paul-Emelie may not resonate well with the broader society, and then there may be thinking in the African-American community that will not underpin the approach that sounds very valid and very humane. Tell us who you are and your connection to this work.
Okay. So I'm Deborah Small. I am the founder and executive director of Break the Chains, Communities of Color in the War on Drugs. And I'm going to do something that's a little different from myself today, which is to do a PowerPoint, which I normally don't do. So people who, I'm going to just pray that this works out.
Slideshow from the beginning.
Okay. I'm here. Okay. You got it? Okay, good. So I have 3 main points that I want to leave people with, which is one, that the common thread throughout all of the criminal justice and drug policy issues that we've been talking about over the last 2 days is punishment. Our laws are based on the belief that illicit drugs are bad and that people who use them are engaged in bad behavior, and that the best way to address bad behavior is to punish them. Secondly, I want to leave with the point that I believe that African Americans have a unique and complicated relationship to punishment. That's both a consequence of our history and the multiple roles that punishment has played in our lives, both politically, personally, and societally. And finally, that transforming that relationship to punishment is possible and necessary if we're to end the practice of punishing our problems instead of solving them. So I want to start by going back and looking at that history. Here we go. Okay. So during the period of slavery, we know that enslaved people didn't have any rights and that they were subject to all forms of punishment. Punishments included being put in shackles, being put in various contraptions, being chained to the ground, being hung and left to die, being forced and being made to walk on a treadmill. And they were punished for all kinds of offenses, from things as simple as disobeying orders or wanting to run away to something more serious as killing a white person. Depending upon how serious the crime was, theoretically would have a relationship to the punishment, but not necessarily. I think that it's important for us when we talk about punishment and our relationship to it to actually remember what the experience of punishment was like. So I'm going to play a little clip from, okay, this is problematic because I thought the media was here. So I had a clip from Roots, which I think was one of the more profound.
It's there.
Oh, okay, good. That, when I clicked on it, it said media not found. It was on the desk. It was on the desk. Mm-hmm. Do you have a flash drive? Whoever had it got it. But anyway, so basically, this was the clip showing Kunta Kinte being whipped. And the reason that I wanted to show it was not just for the visceral nature of it, but to make a couple of points. One is that it was often the case that it was black people who were being forced to enforce punishment on other black people. So in this scene, you see one black slave, enslaved man, whipping Kunta Kinte while the white overseer is demanding that he tell him what his new name is. The reason that he's being whipped is because he insists on holding on to the name Kunta when he's been given the name Toby by his slave owner. And he's whipped continuously until he finally says the word Toby. But the other reason that I wanted to show it is because all the other slaves on the plantation were present watching this event. And the point that I wanted to make was that punishment is a spectator sport. The whole concept of engaging in punishment is for it to be a spectator sport, for other people to see it. Now here, now I'm really not happy, because this particular media clip, which was really important to me, was a clip that was from narratives of slave owners talking about the punishments that they inflicted on other slaves. And I can repeat to you what they said, but it would not have the same visceral impact of hearing the owner talk about how he not only had someone sprayed out and whipped by another slave, but at the end of the whipping, he had the slave shit in his mouth. In the second instance, he has a person who had tried to run away, is laid out, and they're whipped, and then they're laid out, and they pour molasses on his body and leave him out there for the insects to attack him all day and all night. In the third instance, it was again a whipping that was followed by the person being coated with lime juice and hot sauce. And then the slave who imposed the whipping was instructed to piss on his face and in his eyes. And I'm really sorry that we weren't able to play the clips, because I think it's really important for people to understand the actual experience that people went through, and the fact that they were not only forced to witness this, but to actually be participants. So when we talk about the ways in which our communities have been conditioned, we have to understand that we've been conditioned to decades and decades of being both recipients of punishment and also being forced and coerced to inflicting it on others. And that it wasn't just enough that people be the recipients of punishment, but that they also had to be humiliated. So that was why you would have people being pissed on and shitted on. And I want us to think about the fact that our criminal justice system today still relies not just on punishment, but also on humiliation. So following the theme of punishment as spectator sport, that did not end with slavery. And I think it's, again, we forget and don't talk about what the experience was for African Americans in this country in the period after slavery, being subject to what you can't call anything less than mob violence and terrorism. This is the spectator sport of lynching with people watching. This is the spectator sport of lynching. All of those dark dots are people watching. This is the spectator sport of the punishment of lynching. Spectator sport, the punishment of burning. But I want you to think about the consciousness that it takes for people to come out and watch something like that, to see it as entertainment. And then think about Lock Up Raw. And then think about our modern day versions of penal as entertainment. Oz, Orange is the New Black. We haven't changed that much. So after Reconstruction, our justice system geared up very quickly to continue the process of black exploitation. And it was, again, the criminal justice system that was used as the principal tool for that. I think that we forget when we talk about convict leasing that a good percentage of the people who were caught up in that system were children. Nobody in that picture is older than 15 years old. These are the kinds of laws that were enacted to make sure that black people remained in a system of servitude, and that this was the kind of punishment that you could expect to receive for all kinds of minor offenses, things like stealing a chicken, being a vagrant, talking back. I loved the fact that the South came up with these pig laws that that went throughout the South, that if you stole anything worth the equivalent of a pig, $25, that guaranteed that you were going to get a long mandatory sentence. They're quite similar to today's marijuana laws. So the point that I really wanted to make, though, was also that one of the ways that we responded to this reign of terror was to begin to think of punishment as protection. So that at the same time that we were victims of violence, black people responded in part by taking on an ethic in the community that said that you have to keep a tight rein on your children. And you have to make sure that they behave appropriately. And you have to punish any infraction at any time right away in order to make sure that they don't suffer the more potentially fatal punishment at the hands of whites, which black children were told to stay away from as much as possible. You avoided talking to them. In the North, you avoided the same thing, particularly white gangs and white police officers. And so that whole notion of punishment was something that was both inflicted on us and something that we continued for ourselves. Now, I want to talk about sort of the modern experience, what many of us have grown up with. Growing up in the 60s and 70s, the prevailing sentiment in my family and community was still spare the rod, spoil the child. Beatings were quite a regular part of my growing up, generally. But if my mother was particularly aggrieved, she would get an extension cord and lay it onto a bare behind, and that was her preferred form of punishment. Any form of infraction was justified. I'm the eldest of 10 children. My mom was a single parent. I can say that her method of child rearing would be considered excessive to many, but when I think about the situation that she was in, I'm not sure that I want to fault her for that. But what I will say is that growing up, I really hated those punishments, and I became very adroit at being able to avoid them for myself and for my brothers and sisters. And when I became a parent, I vowed that I was never going to beat or spank my son. And I pretty much kept to that. But the truth is that no buts like on the beatings, buts with the punishment, because I replaced beatings and whippings with shaming, with shunning, with not talking to, with all the other things that we do when we want to make our displeasure known. So it took me a long time to understand that, one, I was replacing one form of negative punishment with another. Two, that positive reinforcement worked a lot better. And three, that almost every major problem that I had with my son be many transformative time. In our lesbians, the mentally ill and disabled, I've seen a transformation in our conversation about what to do about the environment, domestic violence, and responsible pet ownership. One of the many transformations that I've also been witness to and participated in is the transformation in our community around the issue of color. As you can see, I'm a very dark-skinned person, but I come from a very multi-hued family. And when I was growing up, it was very common to make fun of people who were dark-skinned. I grew up having people call me darky and make fun of my color and call me nappy-headed for a very long time. And then in the 60s, things began to change. And while I grew up in a very conservative family, like many people of my age, I embraced the Black Power movement. I grew in Afro. I began to celebrate my blackness. By the time I graduated from high school, black was beautiful, and so was I. And that was a transformation that came within a decade. And I started thinking, as an advocate and as a policy person, what were the things that contributed to that transformation in our community? And I believe that one of the many things that helped make that happen, which is something that we don't talk about that much, is the consequence. It was an unintended consequence of Brown v. Board. I don't know how many of you remember the black doll experiment that was done by Dr. Clark and his wife Mamie that demonstrated very specifically and viscerally the impact of segregation on the self-esteem of black children. but it was one of the things that was cited by the court as the reason, one of the many reasons why they found in favor of the plaintiffs and agreed that segregation was unconstitutional because of the harm, because it was so obvious. But one consequences of that was that it actually triggered a conversation within the Black community about the impact on our children of our own internalized racism. And I don't think that it's a coincidence or an accident that exactly 10 years after Brown, you saw the emergence of a Black nationalist movement that was specifically about embracing the very things that we had rejected, that was about celebrating our African heritage, our African culture, our African features, our African skin. But I really do believe that it was important for us to actually be confronted in the way that we were through that experiment in order to make that kind of breakthrough. So I'm going to assume, since it's been the case for everything else, that the media for this is missing too. But it's a very recent clip that I would ask people to look at that MSNBC did very recently, because Brian Williams wasn't around in the 1950s, with Black children, that showed the exact same result, that they are still preferring the white doll over the Black doll. They are still identifying the Black child as the ugly child and the negative one, even though they also acknowledge that the Black child is the one that looks like them. So for me, what I think is that part of our dysfunctional relationship with punishment is our inability or unwillingness, or maybe we've just forgotten to make the distinction between punishment and discipline. You know, I talk to Black people about this all the time, and they're like, well, are you telling me that I can't discipline my child? I'm like, no. Discipline is essential. And I want to just have us think about what those two things are. You know, discipline isn't just something that you do to people. Discipline is what you do to your pets. If you're into gardening like I am, it's something you do to your plants. And like most of the people who work in this building, discipline is something that engages in an area of study. And the reason that we have discipline is to provide some boundaries, some context, some sense of people of what this is that they're doing. But specifically with respect to people and pets and things, the basic purpose of discipline is to enable a person to be self-regulating, to be able to function in their environment on their own. Now, sometimes discipline may involve pain and discomfort, but it doesn't have to. And quite frankly, it works best when it doesn't. On the other hand, punishment almost always involves the exercise of power by a person who has it over someone who has less. Punishment almost always involves the imposition of some form of pain, either physical, psychological, spiritual, or otherwise. And so I want us to really think about the fact that, you know, this isn't, we live in a society that promotes punishment, but punishment doesn't actually tell you what it is that's wanted. Punishment tells you what not to do. It tells you what not to get caught doing. It doesn't actually provide an opportunity for people to know what it is that we want to have happened. So I'm basically an argument for us to stop punishing our problems, to actually think about how we can solve them, to focus on a more love-centered point of view, to base our criminal justice policy and our personal policy on a space that comes from love, because there is no possibility in punishment. But the possibility exists completely when we see the potential in everyone. Thank you.
Thank you. I know we got started a little bit late, so I don't know how much extra time we can have, but another round of applause for all of our panelists. originally I had intended to pose questions to each of our panelists around these topics, but I'm going to throw out a couple of points, and then I'm going to open it up to the extent that we have time for questions from the audience. I liked our final paper and the notion of dependence on punishment or attempting to punish our problems, but it seems in the case when the folks who we're trying to punish are people of color, as opposed to when we see those same behaviors among whites. So I want us to think about the fact that there is a punishment motif around drug offenses for people of color, but we did in fact have a two-term sitting president who was an admitted cocaine user. And the question is whether Barack Obama could have become president having had that same admission. And then there's also the question of unintended consequences. Very often we say that the collateral damage from the drug on wars, the war on drugs, which many people have said was a war on African Americans, were some of the things that were discussed here today, but were they unintended consequences? We know that there's something called conspiracy theorists. There's a 1995 article by a law professor, David Sklansky, called Cocaine, Race and Equal Protection, and he points out that the punitive approach to substance abuse over time has always been associated with drugs, which we then associate with people of color. For opium, it was the connection to the Chinese. For marijuana, it was the connection to Mexicans. For heroin, it was the connection to blacks. And for crack cocaine, we talked about Jamaican posses and, of course, blacks as being involved with those kinds of drug activities. But we have a methamphetamine problem, which most folks refer to as sort of a white drug problem. And it's interesting that we haven't taken quite as punitive approach to the handling of the methamphetamine problem. And so the question is it because we see that as a drug that is mostly used by whites? And so we know that we can take a non-punitive approach to drug offenses if we don't associate drugs with people of color. And so what I like to see moving forward into the future is a way to address drugs as a healthcare issue, and we've done it sort of off and on, but usually if the group that we see that's being affected is predominantly white. And I really appreciate those last comments about how we should not collectively buy into a punishment motif for a social phenomena that really affects people's mental health. It's affected by the conditions under which people live, and sort of the general notion that we all, for various kinds of reasons, live very challenging lives, and some of us choose to handle those challenges by turning to alcohol or cigarettes, and we've decided that certain substances will be penalized and not others, and that certain people will be penalized for using those substances and not others. And so that is the challenge to challenging punishment. Thank you so much. We'd like to open up the floor for questions.
Thank you. Deborah, thank you for bringing in the transformative aspect of this work that we have to do in ourselves as human beings living in a racialized society. And certainly I invite people to check out Landmark and also check out the International Black Summit. You know, raised here in Harlem, there was a place called the Devil's Inn. And we used to go there every weekend and snort dope. And I was wondering how it stayed open so long. Then it wasn't just recently that I found out there was like a relationship between the police and the mafia that allowed it to stay open. So like what's not present in this conversation so far is the relationship between the police department, the mafia, how the drugs got into our community and how they stayed into our community so long. And the other part, which I hope the panel can talk about, and I've heard it here and there, but not really fully exposed, is the whole question of containment. With the Black Power movement, with the COINTEL program, counterintelligence program, with the Black Desk, how all those things are fitting together to keep a people oppressed. So if you can bring into that discussion how those elements are tied into this constant aim of containment. So we know that the police started in the North by hiring former slave catchers in the South. They were used as the ones to come up and bring the model. So we're talking about a straight line relationship. If you can speak to that, it'll be appreciated. Thank you.
And if I can ask if folks would ask their questions, and then we'll open it up to the panelists to respond to which other questions are out there, because I think we are pressed for time.
Okay. I have two questions, but they're both pretty brief and really specific. The first one is regarding Eric Holder's speech. Although it had good intention and sentiment and hopefully practice, do you see this as actually having an actual future, especially after his term is over in 2016? And then my other question is regarding prosecutors. Would you say that it's worthwhile to go into prosecution if you are quote unquote progressive, or is the culture of prosecution too much against sympathizing with defendants and too much for policing and trusting the police's word, that wouldn't even be worthwhile? Thank you.
Okay. Next question.
Thank you. I have two questions and a plug. My first question goes to Dwayne. So you, and along with everyone else, really brought a lot of new insight to a conversation that we've been having for a long time. And I was really curious about the implications of the history that you tell. So if we broaden our understanding of stop and frisk beyond the Giuliani on period and think about it in terms of politics, both the efforts to suppress civil rights mobilization, presidential politics, how does that broadened frame help us to think differently about what we're confronting now? And I ask that particularly, and this is also to everyone, in light of the Floyd decision, now the debate is going to be, so what actually is the meaning of it? What's the remedies that we can call for? And how do we think about this now that we see it's a longer historical arc and not just something that's more recent? My other question was about prosecution. So what is the incentive that prosecutors have to bring PRJ into their, I mean, why would they allow you to do this? And the reason I'm asking is this an arena where communities can be empowered if they understand the equation better? Like, what kind of pressures can be put upon prosecutors to open up the space for you to come in? And the last thing is a plug. So in all of these talks, law was relevant and many times hit upon, but more broadly, the changes of the Supreme Court level, the removal of voting rights, or our ability as constituents to actually get involved in politics and change some of these laws, is now being constrained by 9 people in Washington, D.C. And often we don't really talk about the connections of the rule makers to the games that we have to play. So the plug is on Monday at 6:30, right down the street at Columbia University, we're also going to have a panel where we're talking about Floyd, but we're also talking about Shelby, and we're talking about Fisher, all of the ways that racial justice has basically been eradicated largely by a conservative Supreme Court. So I invite you to come and take up many of the implications of what we talked about there.
Okay, since it looks like now our line got longer, I'm going to allow some responses to the first 3 questions. And since we know that some have been directed at Whitney and some at Dwayne, okay, so I've gotten the message that we got 4 more minutes, so if our responses can be, unfortunately, quick.
Well, Dr. Crenshaw, I guess I'll respond to that question. Floyd, I don't know if everyone is familiar with what happened this August 2013, but a federal judge had ruled that the way New York City police officers enforce stop and frisk, that it was done in an indirect way for racial profiling, and those are her words. It's an indirect form of racial profiling, and that it was therefore unconstitutional as practiced by the police. However, what the federal judge, what she does not rule is that stop and frisk is by itself an unconstitutional law, so police still have this right. Don't be fooled by the words she uses. But that brings it to the point that in general, it's not something that's just so contemporary. It's not something that's been going on just within the past few years, but this has a very, very long history. And Dr. Smalls' point that This history goes back to a history of slavery, a history of, as Khalil Muhammad writes, of condemnation of blackness. It's one where our laws are embedded with the concept of racism and to be against racial minorities in this country. So for Judge Shearer to have issue remedies for stop and frisk, those remedies are still confined by a racist justice system that is supposedly colorblind, but nevertheless, it still is anti-blacks, anti-poor, and anti-people from particular backgrounds, minorities. So what we really need to do is, and the point that I'm trying to make in my research, is that we must look at the structure of our criminal justice system, the procedures and laws that are created. If we carefully scrutinize those procedures and see the effects of those procedures as always negatively affecting people of color or people that are poor, then we should turn to our legislators who create these laws. And we must prevent our legislators from actually passing such laws. Be vigorous against every law that comes out. Question, what are the motives and what is possibly going to be the impact?
And if I could contain that last question response to what would be the incentive for a prosecution's office to bring in your program?
Sure, and actually I'm going to try and address two questions.
Okay, you got like 1.5 minutes.
Okay, the incentive would be to act as a leader and not as a handmaiden of the police, basically. I mean, to the extent that prosecutors, some prosecutors do believe that they are accountable to the communities that have elected them, then those are the prosecutors' offices that would see an incentive in bringing us in to enhance transparency, to enhance accountability, and to exercise true leadership. A prosecutor, on the other hand, who feels that he or she is just there to process the cases that are brought in would never invite us in. So what can communities do to support the work? An aspect of our work that we emphasize is bringing communities along. Typically when we go to partner with a jurisdiction, then we'll let the community know that we're coming so that rather than being punished, basically, when we find disparity, which is what we're looking for, the community will applaud that prosecutor for having invited us in the first place. And so that's what a community can do. A community can ask for prosecutors to be more accountable and more transparent, and then when our findings come out, can support the process of remediation. So,
before you close, there are two things that were said that I really feel the need to respond to. One has to do with the distinction around methamphetamines and the response to it. I think that there's been a tendency within the Black community to do two things. One, to look for ways in which our harms or what's happening to us is worse than what's happening to everyone else. And there's an element to which that's true, but it ignores the fact that none of these laws are really about race. They really are about class. And if we want to know what the plan is for poor white people, look at what they did to poor Black people around crack. They are just a few years to begin to see. If you look into small towns, Midwestern towns in the Rust Belt, et cetera, you see the increase of poor people being arrested and thrown in jail, not just for methamphetamine, but for abuse of oxycodone and other drugs. So I don't want us to think that somehow the system is going to have a different response for these people because they're white people, because the truth is that they are expendable. Their labor is expendable in the same way that Black and brown people's labor has been expendable. And the second thing has to do with our own attitudes about drugs. So if I leave you with nothing else, I want people to ask themselves this question. Would we have been marching and organizing for Trayvon Martin if instead of holding a can of Coke and Skittles, he had been holding a joint and was smoking that? What would our response have been? He would have been just as dead by George Zimmerman's bullet, but I'm not sure that we would have been as present to protest his death because of that. And that's on us.
That's a powerful note to end on. Thank our panelists again.
Thank you, panelists.